Discussion today is dedicated to the effective cross-border execution of judgments. This is not just an economic subject. This is definitely an economic/political subject, and we believe that we are going to have a very interesting discussion. The subject is transplanted from one forum to another because it's always so interesting to discuss. We need to understand the approaches of foreign courts with regard to international decisions, and they are very easy about delegating to the supranational level of different energy-related issues, but they are not often easy about delegating their judicial sovereignty with regard to international court and arbitral awards. There is a lot happening in Russia in this area these days. The judicial practice gives different interpretations for enforcement of foreign court and arbitral awards, and the Russian delegates would know a lot about the Russian practices in this area. Interesting enough, the concept of the single civil code under drafting right now suggests a dramatic change of the approach, and the suggestion is to inform international foreign court awards based on the principle of reciprocity, even in the absence of a relevant international agreement. And this is a rich subject for discussion. I suggest that we organized our session as follows. First, I would like to grant the floor to our speakers from academia and the international community so that they give a look from above. After that, we proceed with practitioners, the practicing lawyers who have to enforce the awards. And finally, we shall ask representatives in charge of the physical enforcement, so to speak, and those will be our colleagues from national enforcement authorities. So, not to make my introduction too long, I am granting the floor to Professor Musin, head of the Department of Civil Procedure of the Law Faculty of St. Petersburg State University, and at the same time the chair of Arbitral Court under the St. Petersburg Chamber of Commerce, and one of the members of the working group drafting the Civil Procedure Code. Professor, the floor is yours. Thank you very much, Mr. Chairman. With your permission, I would like to start with a question to be addressed to you personally. What is the title of our panel discussion? I believe it's national versus universal. In other words, we have an alternative, and I would like to focus on this from the outstart. These collocations, the national approach and international approach, have the conjunction "or" between them. Indeed, we don't have a lot of time for our discussion. That makes me touch upon the most important things during the several minutes given to me. The enforcement of foreign awards is guided by two opposite but interrelated tendencies. On the one hand, it's the tendency or the trend of globalization, bringing different countries together. People sometimes say that trade is against politics. On the other hand, every state is sovereign. If we take the regulating conventions, the relevant conventions, we shall see that both trends come into play. We have to start with the Convention of 1958, but that treats arbitral awards. But there are smaller conventions with smaller scope of applicability. But the trends are still there. Let's take Europe. The Brussels Convention of 1968, which has now been replaced by two consecutive protocols. Take the Convention of Lugano of 1988, which was dramatically reformed or reviewed in 2007. And they prove that all those conventions from the outstart were based on executure principles. But if we take the last convention, last protocol in force from the 10th of January this year, but the executive principle is not the only principle guiding it. So take Europe, take the European Union, take the Association of Free Trade. The trend is as follows. If we take let's take the old conventions of Minsk, 1993. Executive approach is always required. In the Kiev Agreement of 1992, it's slightly different. The executive approach is always in case, but it's the writ that is the basis, and it's issued by the court whose award has to be enforced. So take the Moscow Agreement between Russia and Belarus. The enforcement principle is the reciprocity enforcement is not there. One state's award is mandatorily enforceable by another state. So it's basically the simplification that we see here. And I believe this is something inevitable in the light of globalization. Now, the chair has mentioned yet another concept. Imagine a situation that there is no agreement. Dr. Galperin has said that the draft civil procedure code is planned to have the reciprocity principle as a basis of action, even in the absence of an agreement. And I believe this is exactly right. I'm in charge of drafting this part of the code. But I have to tell you that this principle is not new. We all remember perfectly, we can all remember that when the Code of 1992 was prepared, the Administrative Procedure Code had this same reciprocity principle, and it was supplemented by the international politeness concept. After that, just the international agreement was left, but practice went on in line with these principles. Before, we said, if we don't have an international agreement, that means a ban on enforcement of a foreign or international award. But now we cannot say so. The Board on Enforcement of International Courts of the Russian Federation, I don't remember the wording, but it basically says that the fact of no agreement on legal assistance between Russia and the UK does not exclude enforcement of court awards on the territory of the Russian Federation. This idea was adopted and tested by the European Court of Human Rights. Remember the case Peter Korolov versus the Russian Federation. He was a sailor, and there was a court award in his favor by the court in Cape Town, South African Republic. But we understood that we have no agreement with South Africa, so he did not even try to get the award enforced. He went directly to the European Court, and the European Court cited the resolution of the Supreme Court, decided that in Russia today we have the principle of reciprocity in enforcement. And the fact that the applicant has not even tried to apply to a court in Russia with regard to enforcement proves that he has not used all the national remedies before going to Strasbourg, so his application was refused. So, getting back to the subject of our discussion, I would like to replace "or" by "and" between the words national or universal, meaning international. National and international do not rule each other out. They supplement each other. When the national law is insufficient, the international law can and should come into force. So today, this approach is getting more and more recognized. The Supreme Court award, if approved by the European Court, which have precedental force and which are binding in this country makes a lot of sense. So the idea in the Civil Procedure Code can probably become enacted legislation. Anyway, I believe that if there's no agreement, it doesn't mean that this execution shouldn't take place. There should be a principle of goodwill and politeness and cooperation should be executed by other countries if it does not contradict the laws of this country. Although there are not many cases like that. Being an arbiter, I know from my experience that when decisions of international arbitration are never appealed against, and even if we speak about Russian practice, so if it is in contradiction with the public procedures, we can really identify only just a couple of cases like that. And our courts are very careful with this. So I don't want to spend more time speaking about this. Thank you. Thank you, Valery Abramovich. Let's move over to the next speaker. It will be the General Secretary of UNCITRAL, United Nations Commission on International Trade Law, Renaud Soriol. And this organization has participated a lot in preparation of the New York Convention we have just heard about, and development of model laws in arbitration, where there are sections related to enforcement and execution of international arbitration awards. And since we have changes in Russia taking place currently, and there is a new act now under consideration about arbitration and international arbitration, which are aiming at harmonization with the model law adopted in Citral in 2006. So let's hear more about it. The floor is given to Renaud Soriol.
Thank you very much, Mr. Chairman, and thank you for your kind words about UNCITRAL. It is indeed a pleasure to be here. Good afternoon, ladies and gentlemen. I will be, in the few minutes I will be presenting a new project on which UNCITRAL is about to start working. Of course, we are known as an institution dealing with arbitration. We are the guardians of the New York Convention. We have already prepared a number of standards in the field of arbitration and conciliation. The one I'm going to discuss here today has nothing to do with the enforcement of judgment, but is a project of a draft convention or a possible convention to facilitate the enforcement of settlement agreements resulting from international commercial conciliation or mediation. There are significant benefits to be derived from conciliation that has been noted in a number of General Assembly resolutions of the United Nations. And enforcement of settlement agreements is often cited as one crucial aspect that would make mediation a more efficient tool for resolving disputes. And that is why UNCITRAL's Working Group 2, which deals with dispute resolution, enforcement, and conciliation, is now considering the question of settlement agreements. It is not the first time we deal with that issue. Some of you may remember that we prepared a model law on international commercial conciliation, which was adopted in 2002, and we already gave some attention to the question of enforcement of the result of the conciliation process in the form of a conciliation agreement. The general issues we considered when drafting the model law were the feasibility of preparing a uniform model provision on the enforcement of settlement agreements in such a way that it would be universally acceptable, and what the substance of such a rule could be. The various options were considered, and of course we were struck by the broad variety that existed in current law. Some countries, the settlement agreements would be treated as the simplest form of contract, or a more solemn form of contract, in some cases a notarized contract. Other legislation would approach the issue via trying to equate the result of a conciliation process with a judgment, or work on how a conciliation agreement could have res judicata value, force de la chose jugée in French. But the most frequent approach, I would say, is based on a parallel between mediation and arbitration, and relies on some similarity being drawn between an conciliation agreement and an arbitral award, in particular an arbitral award on agreed terms. I'm not saying it is the same thing. I'm saying that there is a parallel in the approach procedurally taken to enforcing one and the other in a number of countries. Confronted with that broad variety of approaches, the model law took a very prudent and possibly a little bit too prudent approach by simply leaving the issue to the enacting states. I can quote Article 14 of the model law, which says that enacting states are invited to insert in the legislation, and here I quote, a description of the method of enforcing settlement agreements or refer to provisions governing such enforcement. That, of course, is extremely respectful of state sovereignty and extremely confident in the ability of states to agree on an optimal way out, except, of course, that it does not take care of the issue of harmonizing the approach at the international level. And therefore, we started, based on a new proposal submitted to us last year, we started work at the session of the working group this spring in 2015 on the feasibility of a convention that would harmonize a process for enforcing settlement agreements. The Commission endorsed the general policy that easy and fast endorsement of settlement agreements should be promoted. It is clear that drafting uniform legislation is a very difficult exercise. Nevertheless, a convention would probably be worth considering, in as much as it does not try to harmonize procedural law in the various countries, but simply to focus on the expected result, which is the enforceability, and preserves a modicum of flexibility in how the various enacting states may reach that result. Of course, in trying to achieve that result, we used the New York Convention as a model, or it was suggested to us that attention should be given to the New York Convention. And many practitioners have put forward the view that the attractiveness of conciliation would, of course, be greatly increased if we would reach a regime comparable to that of the New York Convention. Let me briefly outline the contents of the proposal. Only a few articles would be needed to set forth the central contents of a convention. The main obligation to enacting states would be to recognize and enforce conciliated settlements that could be based on Article 3 of the New York Convention. This article could also require parties to the convention not to impose substantially more onerous conditions on the recognition and enforcement of international conciliated settlements than are imposed on either domestic settlements or on arbitral awards. If I go a little bit further down into the detail of what provisions would have to be prepared, I think first a set of definitions would be needed. Definition of conciliation we already have in Article 1.3 of the model law. Definition of international we also have in the model law on arbitration and the model law on conciliation. Definition of commercial, I think our traditional approach would be to look at either the model law or the United Nations Sales Convention, where we introduced a notion of commerciality. But of course, we now have, and my neighbor knows that particularly well, we now have the new model of the Hague Principles, which might also give us a useful reference for the definition of commercial. As was the case with the New York Convention, we would have to look at possible exceptions. Provisions for exceptions that come to mind would be the incapacity or coercion under the law applicable to the parties, the invalidity of the conciliated settlement under the law to which the parties have subjected it, or under the law of the country in which it was made, the subject matter of the conciliated settlement, which may be not capable of settlement through conciliation under the law of the country where recognition and enforcement is sought, divergence with public policy, of course, and express exclusion of the application of the convention in the conciliated settlement itself. We may also have to envisage a number of reservations to be provided to enacting states, possibly to provide that a party to a conciliated settlement shall not be eligible to seek recognition under the convention if the party has that place in business in a state that is not a party, the reciprocity reservation, although of course we are not recommending that, applying the convention to non-monetary elements of conciliated settlements only to the extent specified in the reservation. And the last possibility of reservation we are considering is applying the convention only to conciliated settlements in which the parties to the conciliated settlement have explicitly agreed that the convention will apply. With those relatively short rules, it is clear that, and I would stress that point and close on that point, that we would not add any substantive rule or procedural rule to harmonize the way in which the conciliated settlement would be reached. That is the state of the project. As you can see, it is very much in its infancy. It will be subject to further discussion to assess more precisely its feasibility. So this is only the starting point, and I'm sure there will be considerable evolution. I would, of course, invite all of you to participate in that discussion, and I'm already glad to report that the Russian Federation is, as always, very well represented in that working group. Thank you.
Спасибо большое, господин Рено.
Thank you very much, Mr. Seriol. Thank you very much for discussing and describing this interesting process in arbitral. When I was a student, I was really surprised how far the international arbitration was operating. The New York Convention has existed for almost 60 years, and so many countries ratified this convention, and now we are moving even further, and it is interesting that these conciliation and mediation procedures will be acknowledged and present at international law. At the same time, we don't have mechanisms for enforcement of court decisions at the national level. Although we are being very optimistic in terms of international politeness and cooperation, but still there is such an issue, and countries need to sign some bilateral agreements or this multilateral conventions. But I'm sure we can see this light at the end of the tunnel.
and it is brighter or dimmer for some of the countries, but I'm sure that this light is provided by the Hague Convention and some universal agreement in this judgment project are being developed. And I'm happy to give the floor to Christopher Bernasconi, who is going to speak about these issues and about some other issues that Hague Conference is working on.
Thank you very much, Mr. Chair, and good afternoon to everybody. Your Excellency, Mr. Minister, an honor to have you here. Thank you. We are presented with an alternative for the program, yes, national or universal. It will not come as a surprise to you that the answer from the Hague Conference is, of course, universal. For as long as we understand recognition and enforcement of foreign judgments as establishing conditions for the recognition and enforcement of foreign judgments, because it goes without saying that the actual execution, of course, remains subject to domestic law. So the answer to the alternative or to the question posed, I think, is very much both. They should go hand in hand, because certainly we at the Hague Conference, we do not deal with substantive or procedural matters that is left to domestic law. But the Hague Conference has had various attempts, yes, in developing a framework for the recognition and enforcement of foreign judgments. First attempt led to the 1971 Convention, which was not successful, only ratified by, I think, 5 states. In 1992, the membership of the Hague Conference decided that we should embark on another attempt to develop a new convention on the recognition and enforcement of foreign judgments, and at the same time also develop a catalogue of direct grounds of jurisdiction on which basis the national courts could assume jurisdiction in cross-border situations. Well, to cut a long story short, that project failed. It failed because exactly the direct grounds of jurisdiction side of things. We had, I think, a very good basis for the recognition and enforcement chapter of that convention, but there was simply no consensus as far as the chapter on direct grounds of jurisdiction was concerned. And we don't have to elaborate on this right now, but you have to understand that for many, many jurisdictions, these are very basic constitutional issues that are at stake here. And so it makes the challenge quite remarkable if you want to harmonize these things at global level. But this first effort produced a very, very important spin-off effect, and that is the Choice of Court Convention of 2005. Because in the course of the negotiation of the original judgments project, we realized that there was actually consensus on how to deal with choice of court clauses. And that led to the 2005 Hague Convention on Choice of Court Agreements. What does this convention do? Essentially, it does 3 things. It says that if 2 parties to a commercial contract add a clause that says something along the lines of any litigation arising out of this contract shall be heard by the courts of St. Petersburg, then the courts of St. Petersburg have jurisdiction and must hear the case. Full stop. Perfect certainty and predictability as to the planning of your judicial litigation. You chose St. Petersburg, you end up in St. Petersburg. If the plaintiff decides to bring the action at another place, another jurisdiction, the courts in that other contracting state would have to refuse to hear the case on the basis that there is a valid choice of court agreement in favor of another jurisdiction. So you avoid parallel proceedings. And finally, the third element of the Choice of Court Convention is that the resulting judgment from the St. Petersburg chosen court has to be recognized and enforced in other contracting states. That is subject to a few exceptions here and there that we don't have to elaborate on here, because really the principle is the recognition of a court decision based on its jurisdiction because of a valid choice of court agreement. What is the status of this convention? As we speak, it has one contracting state, Mexico. But things are about to happen, and very important things are about to happen, because the convention has been signed in the past by the United States, by the European Union, and I can inform you here at this stage that the European Union will actually approve this convention in 2 weeks from now. It will bring, therefore, for the European Union as such and its member states, it will therefore bring this convention into effect most likely on the 1st of October of 2015. We therefore believe that this convention will develop quite a new dynamic, or will have a lot of dynamic developed in the course of this year, because other states are most likely going to be invited to do the same and also assess the possibility to ratify this convention. The United States is preparing ratification. They are still discussing as to whether or not to implement it at federal level or state level. That is the only crux that is left in the US. There is political consensus that they should join and ratify this convention. Singapore has recently signed this convention and is also preparing ratification. And we know of a handful of other jurisdictions, including the Russian Federation, I'm pleased to say, where the assessment of this convention and the possibility to become a party to it is undertaken. I do remember a very specific discussion I had on the Choice of Court Convention with the Chief Justice of Singapore, Justice Menon, who, as you may know, has a very strong, impressive past career also as an arbitrator. And when I explained to him the Choice of Court Convention, after 5 minutes, he looked at me and said, "I'm convinced that is exactly what we need." And you know why? Because as important as arbitration is, as diligent as arbitration is often conducted, and as practically important as it is, in particular also for big commercial players, arbitration is getting more and more expensive and less accessible for small and mid-sized companies. And it is precisely with a view to offering a valuable alternative to arbitration and the highly successful New York Convention that the Choice of Court Convention, 2005 Choice of Court Convention, should be ratified by the states so that the small and mid-sized companies have this alternative to rely effectively on their Choice of Court clause. So that is one aspect of our work, and I'm sure the Choice of Court Convention, if only for its simplicity, because it's quite a straightforward, easy to understand convention, is promised actually a very bright future. But there is more to come, because in 2012, the membership of the Hague Conference decided that time was ripe to resume the old judgments project and give it another shot at trying to establish a convention on the recognition and enforcement of foreign judgments in civil and commercial matters, more generally, not just based on a Choice of Court clause. And if you listen carefully, you realize that I now only talk about recognition and enforcement. Because clearly, when this new discussion was put back on track, the first emphasis now is on recognition and enforcement. Jurisdiction is still there. There are some of our members that make it quite clear that for them this aspect continues to be as important as it was back in the 90s when we tried to develop a convention that would also include a comprehensive catalogue of grounds of jurisdiction. But we all understand that success is more likely if we first focus on recognition and enforcement, and then see to what extent we can possibly add direct grounds of jurisdiction. Talking in my personal capacity, not as Secretary General of the organization, because of course I respect the position of all of our members, Personally, I remain to be convinced that things have changed to such an extent from compared to the 1990s that now we would have winning conditions in place to also elaborate a comprehensive catalogue of direct grounds of jurisdiction in civil and commercial matters. But this is very much work in progress, and we'll see where this leads us. But for the time being, it's recognition and enforcement. Where do we stand? We have a very active working group that is preparing a draft text. So we are at experts level. We are not yet at official state level. I'm pleased to say also in front of the Minister of Justice of the Russian Federation that we are extremely pleased to see the Russian Federation part of this working group and playing a very active role in its development. It's very ably chaired by David Goddard from New Zealand, QC David Goddard, and this group is doing, in my view, really excellent work. And we are not stressed by time. We will take the time it needs to sound good product. Just a few words, if I may, on the current structure of the draft, which is clearly based on the principle that there should be recognition and enforcement of foreign judgments in civil and commercial matters without a review of the merits. Full stop. That's the principle established in Article 4. There will, of course, be a small catalogue of grounds on which you can refuse the recognition. These are the traditional procedural grounds like lack of effective service or lack of procedural fairness or the violation of basic procedural rights. But the more interesting and far more delicate aspect of this work is establishing the conditions of the nexus of the action and the state of origin that has to be there, and a nexus that is given and which is strong enough for the state of recognition and enforcement to go ahead with recognition and enforcement. And as it stands, there is a very interesting Article 6.3 of the draft, which I invite you to review on our website. All this information is publicly available, and I had prepared a PowerPoint, but in the interest of time, I have decided not to use it. But essentially, Article 6.3 says that the foreign judgment can be refused if it does not comply with one of the following requirements. And one of the following, all of these following requirements establish a nexus that the negotiators feel is strong enough for there to be a valid ground for recognition and enforcement. And the first few required grounds for nexus are very straightforward and traditional. For example, if the person against whom the judgment was rendered was habitually resident in the state of origin, well, you have close enough of a nexus, and that should lead to recognition and enforcement if no other grounds of refusal is fulfilled. Same goes if the judgment has been rendered against a person who actually brought the action in the state of origin. So you decided to start proceedings in state A, things went south for you, you lost the case, well, you still have to bear the consequences, and the judgment against you will be recognized and enforced in the other contracting states. Or, and that sort of closes the loop to my initial reference to domestic law, there will most likely be a provision that says essentially if the court of origin would have had jurisdiction in accordance with the law of the state addressed for recognition and enforcement, then you also have the required nexus between the action and the state of origin where the judgment has been rendered. Where it becomes a bit more difficult is when you move away from these traditional indirect grounds of jurisdiction or jurisdictional filters, as we call them, and that is in particular when so-called activity-based filters or grounds of jurisdictions come into the picture. But as things stand, it would be enough
for the person against whom the judgment was rendered to maintain a branch, an agency, or another establishment without separate legal personality in the state of origin, and the claim arose out of such an activity. There you have sufficient of a nexus between the state of origin, the resulting judgment, and therefore it should be recognized and enforced in the state of destination. Same obviously would go if there is an express consent to the jurisdiction. Probably the most tricky ground of jurisdiction that will still need to be discussed in further detail is if and when the person against whom the judgment was rendered, and here now I quote the draft as it stands, intentionally engaged in frequent or significant activity in the state of origin related to the obligation at issue. So you essentially conducted a stream of commerce into the state of origin of the judgment. That creates a nexus that is relevant enough under the convention with the state of origin to have jurisdiction, and the resulting judgment should then be recognized and enforced in the state of destination. There are some other grounds that I'm not going to relate. Let me just finish that by saying that one of the remaining challenges of these discussions will be to see exactly how, if at all, how to deal with direct grounds of jurisdiction, if that should be part of the same instrument, if it should maybe become part of a separate instrument, maybe of an additional protocol or what have you. But most importantly, I really have to stress that this is work in progress. I only could give you a sort of a snapshot picture of where we stand right now, but I really hope that maybe next year, when the organizers will be so kind and again extend an invitation to the Hague conference, that we could come back and report on the progress that has been made, because we are hopeful that we could actually enter the stage of official state negotiations as early as next year. Again, because the working group is doing excellent work, and the product is developing in a really nice way. Thank you very much for your attention.
Спасибо большое, господин Бернаскони. Ну, я думаю, что я выражу общее мнение.
Thank you very much, Dr. Bernasconi. I can definitely say that we are looking forward to seeing you here next year. We are staying hopeful of good implementation of the project you are working at. We're kind of completing a block of discussion with regard to our foreign colleagues' progress, and we are now inviting the floor to speak. Dear colleagues, anybody has any questions or comments, make sure you use the microphone, please. And please introduce yourself and the panelist you address your question to. Svetlana Vasilkova, Managing Partner of NVC Consulting Company under Gazprom. I'm happy to welcome all the panelists here and all the delegates. And here is my question. Today we have mentioned that at the international level today there are such multilateral conventions as the New York Convention of 1958, and former USSR states have joined it by now, except for Uzbekistan. Also, we have the Convention of 1964 on international trade arbitration. Russia also has a number of bilateral agreements with India from year 200, with Algeria, with Iraq, with China, with Yemen. And those bilateral agreements have provisions to the effect that the awards or decisions of international courts of arbitration have to undergo a special procedure And today, the literature and the current judicial practice are not paying enough attention to whether or not recognition and enforcement should relate to foreign court decisions if they contradict the norms of Russian material law. What are we supposed to do with this regard? Boguslavsky, Korabelnikov, Sukhanov, and a number of other renowned Russian scholars are saying that we'd rather maintain the status quo. But it looks like if we don't stick to the status quo, and if we find more grounds for non-recognition and non-enforcement of foreign decisions, then Russia will become a non-compliant country under an international agreement. I would like to know your opinion with regard to this. Thank you. Well, this is a question I would rather refer to Professor Musin at first. Thank you very much for your question, Svetlana. My response would be simple. We need to discriminate non-enforcement of a decision by the country of origin, by the state court of the country of origin, and non-enforcement of an award from a court of arbitration, whether domestic or foreign. Let's take the Civil Code or the Civil Procedure Code. We shall see the same in both. That one of the grounds to refuse enforcement of a state court award is a significant offense against the material procedure right. That's misapplication of a law or non-application of a relevant law or misinterpretation of a law. You don't see that in New York Convention. To refuse enforcement under the Geneva Convention or to cancel a decision, you need to comply with an exhaustive list of offenses, either a misformulation of the crime or non-information of the court of your current position or violation of the public procedure. Let me give you an example I always use when I talk to my students. Let's take a case heard by a state court. The case is about cargo transportation, and the court misqualifies it as a contractual agreement, so the award will be cancelled. 100%, trust me. But if a similar situation happens with a foreign court or tertiary court award, then the Court of Appeal will say that yes, there is an offense against legislation, but there is no grounds for refusal. So we have to abide either by the public order criteria or the list of offenses. Even the material or procedural law is broken, the award will have to be complied with or enforced if there is a tertiary court decision. Thank you. Do we have any other comments or questions from the floor before we proceed to the next part of the discussion? Please be brief. Mr. Petrovich, I have another question to Professor Musin. Starting from which moment of time you believe the decision of an international court of arbitration to come into force for the Russian Federation and for legal entities and for state agencies? Is it from the moment of announcement or from the moment of recognition in the Russian Federation? My second question to you is also as follows. Don't you think that we want to harmonize our procedural codes, the Criminal Procedure Code, the Administrative Procedure Code, and the Civil Procedure Code? I believe that all our countries should have some liabilities with regard to the signatories and to state agencies. What is your personal opinion with this regard? What is your opinion as a professor engaged in this subject? Let me first take your first question, and then I shall ask you to clarify your second question. Okay, the first question, if I understand you correctly, is starting at what time the tertiary court award comes into force, whether it's national or international. If not stated otherwise, it comes into force once the award is made. But this can also mean some duration. The state court makes the announcement of the award immediately, but the tertiary court awards can be given after the hearing are over, so hearing may be completed with no award announced. So when the parties get copies of the formally signed tertiary award, then that's the time it comes into force. Now,
could you please clarify your next question? So we treat this notion slightly differently. So this tertiary court element is taken out. So my question is, do we accept that international awards, international arbitration awards, despite the position of the Constitutional Court, should be compulsory for public authorities, for example, not only for the parties to this arbitration consideration, or you believe it is not necessary? Do I understand you correctly? Are you asking this question about whether these tertiary court's decisions have prevailing power? Yes, I believe so. Because if we take cases when the national court cannot ignore the arbitration court award, and when we say that some national level court is going to consider a case, and there's already some decision about this case of an arbitration court, they have to take it into account. Yes, there's no contradiction. Thank you very much. So it seems that we are discussing very practical things. Now, let's give the floor to our next speaker, Jonathan Kelly, who is partner of the London office of Cleary, Gottlieb, Steen and Hamilton, and we hope that he's going to cover a British and European experience in this respect.
Thank you all for attending today. It's a great privilege to be on such an esteemed panel. I'd like to start just by associating myself with Professor Mewson's introductory comments about the or being replaced with the and. Certainly, in my experience as a practitioner, at the moment it is national and universal criteria. I'd also like to agree with Christoph's comments from the Hague Conference perspective that it would be good for it to be universal. Because, of course, one of the things that we're talking about here is the tremendous difficulty in practice of achieving any kind of uniformity across different jurisdictions and countries. So what I would like to talk about very briefly, just for a few minutes, is to provide a high-level route map of the possibilities for enforcement in Europe and slightly further afield, and in particular to identify the different regimes that apply. And then what I would like to do is to illustrate with a case involving, strangely, or maybe not so strangely, two Russian parties, Aeroflot and Mr. Boris Berezovsky, the late Mr. Boris Berezovsky, in the London courts, and how, in practice, these issues are dealt with by the English courts. And before I do so, I'd just like to make a couple of preliminary remarks, and they are in the nature of perhaps more philosophical remarks than commercial. But it's important as we have this debate to understand the fundamental philosophy that underpins the whole question of enforcement and recognition. Because we talk about state sovereignty on the one hand, and as Professor Mewson talked about, we have politeness or courtesy or comity, as it's sometimes talked about on the other. And the whole question of enforcement of judgments really is an exercise in deciding where the boundaries lie between the exercise of one state's authority and the acceptance of that exercise by another state. And in times gone by, possibly even now, sadly in some cases, those issues would be resolved by conflict, by war. But now they are resolved by this very careful and very cautious approach by courts in different countries around the world to consider to what extent, when the original court says, I have decided something, the enforcing court says, I accept your decision with little or no challenge. And so the key question is, what level of acceptance is there when a Russian court is asked to look at an English judgment, when an English court is asked to look at a Russian judgment? Let me just tell you what the different regimes are, because it might be helpful to have the architecture and the structure of international enforcement. There are obviously, I say obviously, there are generally two routes, one through domestic law and one through international law, which underpin the basis of enforcement. And some jurisdictions would recognize and enforce a judgment only if and to the extent that there is actually an international treaty in place between the relevant countries. So, for example, subject to Professor Muson's point, which I'll come back to, Russia is a country where typically there is a requirement for a treaty, although the arbitrage courts now appear to enforce judgments even in the absence of a treaty where there is reciprocity, as Professor Muson explained. You have certain Western European countries, such as Austria or Denmark and Sweden, who are in the same position. The second category of recognition or enforcement is where you have such enforcement in the absence of a treaty, but with a series of hurdles and obstacles that you have to overcome. And those will typically include finality, so the finality of the original judgment, jurisdictional competence, which will often be established by service over the relevant entity, and obviously compliance with due process principles and public policy. Finally, as I mentioned, reciprocity. So an example which I'll come back to when I talk about the Berezovsky and Aeroflot case is the UK, which in the absence of a treaty or another international instrument will enforce a judgment provided certain criteria are met. The point that I made in my philosophical remarks, if I can describe them so grandly, about the way countries relate to each other, is really brought into sharp relief when you start to look at the international position outside of the domestic jurisdictions I've just described. And that is because more often than not, what you see is a geopolitical and geographical gathering of states who, for historical or other reasons, have developed a very close relationship, and on that basis, essentially trust each other more. Europe is the classic and closest example, and as previous speakers have said, there has been a long tradition of either regulations or conventions under which enforcement is automatic, subject to very limited exceptions. So you had the original 1968 Brussels Convention, you have the 2007 Lugano Convention, which replaced its 1988 predecessor and brought in Iceland and Norway and Switzerland into the EU bloc. And you now have the Brussels Regulation, which has just come into force. And that gives tremendous possibilities for ease of enforcement. I had a case which finished 3 weeks ago where I was acting for an Italian bank who was suing an Italian municipal authority under various financial instruments. in the English courts because the contract was governed by English law, and we were able to obtain a judgment from the English court, and with no real defence available to the Italian municipality, our colleagues in Italy can go and enforce that under the Brussels regulation as of right. There are only three essential defences to automatic recognition. One is manifest contrariness to public policy. And again, you see the same principles coming out in whichever context you talk about, whether it's the Kiev Convention that Professor Musin described or the Brussels Convention or regulation. The second is that the defendant has not been served. And again, it's standard fairness, and it's caused difficulty in Europe over the years with default judgments, for example, where parties, by definition, have never made an appearance, and the courts have struggled to work out what they should do. And the way they've resolved that now is to say that if you can show that a party has been served, so in my Italian case, we personally served the papers on the municipality, then it is clear that it's a conscious choice on the part of the defendant in that case to avoid engaging with the proceedings. And in those circumstances, they have essentially given up their right to defend themselves. And then finally, where you have a judgment that is contrary to an earlier judgment, and again, there are no surprises there, it's essentially a question of making sure that judgments are reconcilable. So, as Christoph mentioned, and I'm not going to talk about it again because he described it very fully, you have the Hague Convention on Choice of Court Agreements, which is supplementing this regime. I talked briefly about the Kiev Convention. Picking up my geographical theme, there's the Inter-American Convention on extraterritorial validity amongst Latin American and Central American countries. And so what you end up with in practice is a patchwork, a sort of mosaic of possibilities where if you are within the Eurozone, it's very straightforward. If you are contracting across different continents, much less straightforward. If you have a judgment and you want to come to the UK to enforce against assets, how will the court go about it? Let me conclude by just describing briefly a case that came into the Court of Appeal in the UK last year, so very recent and a very helpful summary of the principles and the approach of the court. And as I say, it involves Russian parties, so sort of very relevant for this audience. And essentially, the background was that the claimant, Aeroflot, had been defrauded of several hundred million rubles by Mr. Berezovsky and an accomplice. And there were two judgments in the Savlovsky District Court in Moscow and the Golovinsky Court that were made against Berezovsky in 2007. In 2011, Mr. Berezovsky and his accomplice left the Russian Federation on the day of the judgments or shortly thereafter. In 2011, Aeroflot went back to the court to say, can you please uplift the amount of the award because inflation has eaten away at our damages. So there was an indexation uplift. And the courts did so. And so the issue for the English court was whether, how to approach this whole process. And it was interesting because to me, it showed an increasing matureness and a closening of the relationship between the English courts and the Russian courts, because the first instance judge refused to enforce the judgment, even on a summary basis, on the footing that the original awards offended against the finality principle, where you can't reopen a judgment and relitigate a case. So the indexation process was said to offend against the finality principle. The surprising thing about that decision was that it was made on a summary basis. And so there was not even any chance for Aeroflot to introduce Russian law expert evidence about whether or not the finality principle had been breached. The Court of Appeal took the opposite approach, which I think was to its credit, and came to the view that actually when you have these situations, deference to foreign law, comity with the Russian courts, dictated that Aeroflot should at least have the opportunity to introduce expert evidence about Russian law that would be determinative of the case. And for that reason, it couldn't be dismissed on a summary basis, but should go forward to a full trial. And I'd like to conclude on that mildly optimistic note, if I can describe it in those terms, because certainly as a practitioner, what I see and what I've seen developing over recent years is much more understanding and reciprocity, not in a technical sense, but reciprocity in terms of trying to accommodate the views and judgments of foreign courts with scrutiny and with proper safeguards in place. But the old days of either non-recognition or practical non-recognition, I think, are behind us. And I'd like to finish where I started, which was to associate myself with the view that universal criteria must be the way to go. And we are gradually, particularly with my colleague on the left here, heading in that direction, but the sooner the better from my perspective. Thank you very much for your time.
Спасибо большое, господин Келли.
Thank you very much, Mr. Kelly. Yes, you added some optimism, and it is. It's understandable that the more legal, practical things we see in this area, and the fewer political, the more legal practices we see, and the fewer political aspects are involved, the better it is. And I would like now to give the floor to Vasily Kuznetsov, who is partner of Queen Emmanuel, Urquhart and Sullivan. I hope you are going to speak about Russian experience. Yes, I'm a partner of this Queen Emmanuel company, and I would like to thank the chairman for this opportunity to speak. I was requested to outline Russian practices and problems. I have only about 10 minutes, so I won't be able to describe the whole range of issues, but I agree with the previous speaker, that this reciprocal principle, this is something obvious now, but the practice is becoming more and more complex, and we see that a decision of one court should be enforced in another jurisdiction, and it is necessary that Russian courts should analyze very carefully, they should scrutinize how this was happening in other countries, and how to ensure that the outcome of those previous cases should be incorporated into the current practice. Various lawyers might have different experience of work with Russian courts, both positive and negative. Our courts are criticized very often, and sometimes it is justified, but we see through our practice that very often Russian courts take a very balanced approach towards international courts' decisions. And I believe that it is possible to reach great success in Russian courts as well, using civilized European cases. I would like to describe a case of UCOS, when the British court decision was enforced. We were representing a syndicate of several banks, international banks, and definitely at that time probably any sort of a decision, even of some Nigerian court, would have been enforced, or at least there were expectations. So there were several rounds, first instance court and second instance, and again the first instance, and the decision of the British court was enforced, so it was our claim, should be enforced because of the reciprocal approach, and secondly because Britain is part of various conventions, human rights conventions and other documents, and all this all together means that this is this agreement, some sort of agreement that we need to enforce their decisions and they need to enforce our decisions. It was not a simple case. That British judgment was taken on the basis of summary, there was no detailed investigation, and it was not just one document with the decision, but it was a number of documents, and it was quite unusual for Russian courts. It was necessary to calculate various payments to the banks on the loans, and then the debt in relation to interest rates and so on. So it was a number of documents, a number of orders, but it was one decision of the court, and we were successful. And the first instance took a decision, yes, that these judgments had to be enforced on the basis of the reciprocal. There were other considerations as well. And the position that we developed, and it was supported by courts, it was also reflected in other decisions. So, and some of lawyers, they were stressing the fact of the totality of agreements. And so decisions of Irish courts and the Dutch courts were also enforced here on the same principle.
There was a very interesting situation with the Dutch award, because that was not about collection, but that was about enforced transfer of equipment. It was a specific performance enforcement. If we even take the general law, the common law approach from the UK, you may have some difficulties in enforcement with regard to equipment transfer decision. Now let me tell you about the second case. That was a case versus Alrosa. We had to enforce the Stockholm Court of Arbitration award, and that was a very sensitive dispute for both parties with regard to construction of major production facilities in Russia. We had to enforce the decision in Irkutsk, where Alrosa has a very important company. When we flew over there, we had to live in an Alrosa-owned hotel. The Irkutsk court was very attentive to all those technical problems that were involved. For example, when we enforced the decision in Sweden, there was a hearing, there was a litigation with regard to cancelling the decision. So Alrosa suspended the enforcement in Russia until the Swedish court completes its consideration. There were several court sessions, and finally the judge of the Irkutsk court agreed to us. She refused to suspend the consideration, and she said that we could enforce even without waiting for the Stockholm decision. Then, after the substance was considered, we had this very technical matter. Alrosa stated that the grounds for charging the funds from there was not properly applied by the claimant, who was our client. So Alrosa could not properly speak on their own behalf, which was an offense against the procedure, and that was an offense against the Alrosa's right to properly state their position in court. This is yet another complicated technicality. We had to figure out the way they applied, whether or not Alrosa were given a chance to provide all clarifications. If there were any deficiencies here, what was their meaning with regard under the Swedish law, and we had to find adequate examples from Swedish practice. We got opinions from Swedish experts, and finally the judge took a very correct and tight line of behavior. So Alrosa had to agree to amicable settlement. So both parties agreed to settle. The third case I would like to tell you about is with relation to Dmitry Firtish, the Ukrainian businessman you probably have heard about. It was about the alienation of the Hungarian gas trading company. It got sold for $1 to Swiss gas company, and Russian law was chosen as the applicable law, but not the Russian jurisdiction. There were several litigations in Eastern Europe, including Hungary, and the Hungarian court said ruled that the arbitration clause was not there, and the jurisdiction should be Hungary. So Infest had to be returned to Dmitry Firtish company, and Rosgas went to the MCAS court, so there was a question of the judicial competency, given that the Hungarian courts started working by that time. So our court decided that the jurisdiction was okay, and it was challenged by the Moscow Court of Arbitration, and we came into play after the challenging claim was filed. So we stated that Hungarian decisions were not exactly binding. They were binding and due to be enforced without any special procedures. That's the binding force of the Hungarian decision. And we referred to the presidential decree of Supreme Council decree of 1980 with regard to automatic recognition by default. Our second argument was that under the agreement between Hungary and Russia, the court decisions relating to non-property matters should be automatically recognizable by default without any separate litigation. The case was very complex. We even had to challenge the judge. The judge of first instance was very fast in considering the case, and he approved the competencies. So we appealed to a different instance, and the decision was that the court and the Court of Arbitration did not take into consideration the binding force of the Hungarian decisions, and so they brought the case down to the first instance again for reconsideration. After the arbitrators heard that this was the approach that defected their jurisdiction to a certain extent, they decided to reject the case, and they said that the agreement was null and void. That was their decision, and they had some difficulties with the Hungarian courts, so they decided that it was kind of a forced decision. The interesting thing here is that as the decision of the MKAS was challenged, we have to remember that the Hungarian decisions were substantial. They found out the decision was that the agreement was not properly concluded. On the other hand, there were procedural decisions with regard to whether or not the arbitration clause was in place and whether or not the Hungarian courts were eligible to hear this case. So when the competencies decision was made, there was a very serious issue of the competencies of the the competences of the Hungarian court with regard to procedural matters. So there was a Hungarian court decision with regard to the appeal. So the Court of Appeal of Hungary stated that the clause was not there and the validity of contract was at question. This automatic action, and we insisted upon it, could not only relate to the substance of the case, but also there was this appeal court, a Court of Appeal decision, which resolved the problem of jurisdiction. So yes, it was a procedural issue, but it finalized the consideration. So under the decision of the Presidium of the Supreme Council and under the agreement between Hungary and Russia, such decision should be recognized automatically by default. This brings me to the conclusion of my presentation, and I hope a similar deliberated and attentive approach could be always undertaken with regard to European Court's decision. Remember, we heard the speech of Dmitry Medvedev during the plenary session, and he said that the Russian Federation enforces foreign courts' awards if there is a relevant agreement. He never said anything about reciprocity or the mutuality of agreements. We hope that the Russian courts see this as a kind of a generalization, not as an instruction. Thank you very much. Do we have any comments or questions from the audience? Well, if not, we can proceed to our final block of discussion. Remember, Professor Musin told us about the way he talks to his students. I teach executive procedures. So when my students come to my classes, they are supposed to know civil procedure. Well, sometimes they do, sometimes they don't. They are always complete lawyers, you know. But I tell them, you may draft a good agreement, you may win the litigation, but that's just the start. You are only a good lawyer if you can get the money in the very end. It's not about bringing the writ to your customer, client. Lots of our speakers today have mentioned the recognition-related issues and the enforcement-related issue. International agreements and reciprocity are just the tip of the iceberg. Next to that, we have a huge range of issues, and one of them is the enforcement of specific performance. How can you change the subject of enforcement? And this has a lot to do with procedural and material law. And we are now proceeding to the presentation of Mr. Patrick Sanineau, President of the French National Chamber of Judicial Officers, and I'm sure he will share with us his experience in enforcement of foreign court awards.
Express all my gratitude today to stay here with you. So, we all noted the common need to improve the effectiveness of cross-border excuse me. We all noted the common need to improve the effectiveness of cross-border enforcement of judgments for judicial and economic purposes. The enforcement of judgment is closely linked to national sovereignty by the constraints imposed by enforcement measures on debtors' assets. Enforcement proceedings are the monopoly of the states that entrust the bailiff to implement them in accordance with their national laws. Therefore, this territoriality has a dual effect on cross-border enforcement of judgments. Firstly, if you want to enforce a decision in a foreign country outside Europe, you have to follow an exequatur procedure to obtain the recognition and the enforcement of your title of the state of enforcement. And secondly, you must know the rules of enforcement in the foreign country concerned competent enforcement agents, proceedings, etc. Nevertheless, if we take the example of the European Union, significant progress has been made during the last few years. Now, the European Union recognizes the principle of mutual trust in the court and legal systems of the member states and has progressively simplified the exequatur procedural stage until its final abolition in civil and commercial matters. Indeed, since the 10th January 2015, all decisions made in member states are automatically recognized and enforceable in other member states. This mutual trust principle has most certainly made in member states are automatically. This mutual trust principle has most certainly improved cross-border enforcement and the recovery on debts in Europe. For many years, people thought that one day, especially in Europe, we could harmonize the different laws, including the right of enforcement. However, the last 20 years has shown that this objective may be unrealistic. Firstly, from a political point of view, countries do not wish to lose their sovereignty. And secondly, from a technical point of view, the differences of languages and cultures vary considerably, and the differences between domestic laws, likewise, even among similar civil law or common law jurisdictions. In practice, the common values shared by the countries are fundamental rights, but they do not allow harmonization. As a consequence, if harmonization is not a realistic option, we shall shift towards an effective means of cooperation between the legal systems. Cooperation could be based either on convergence on a long-term basis or on an immediate coordination of national procedures. On the one hand, convergence of national legal system regarding enforcement proceedings will be a guarantee of a better interoperability between the systems. The establishment of diverse projects on improving domestic laws through mainly financial assistance from international institutions are contributing towards reducing the gap and the differences between domestic legal provisions and a better understanding of an interaction between the legal systems. Beyond this convergence, on the other hand, the other possibility is the coordination of national law, which nowadays is the aim of the European Union and obviously will take time. This coordination must enable bailiffs to share their best practices with respect of national specificities and set up different tools to inform citizens and companies and on practical cross-border debts recovery issues. This coordination aims at improving the efficiency of enforcement proceedings and at the same time to facilitate access to law for citizens. I am also European President European. The European Chamber of Bailiffs, created in April 2012, manages and sustains the European projects to enhance cross-border cooperation of bailiff and participate in the consolidation of a European area of justice. Directory of European Bailiff e-notes on national enforcement proceedings, e-service of documents, e-learnings modules on the European regulation. These are our comments. Maybe less ambitious coordination supported by experienced legal professional is a real model for the future. And for the end, you may have noticed that the future of the improvement of international enforcement through bailiff relies on an effective coordination between enforcement engines and obviously between the ministries of justice of different countries, especially where bailiffs are no independent professionals as they are in France, but are government officials. Thank you, ladies and gentlemen.
Спасибо большое за такое интересное, емкое выступление.
Thank you very much for this most interesting and comprehensive intervention. I'm now happy to give the floor for our final presentation by Mr. Leonid Parfenchikov, the Director for the Federal Court Bailiff Service of the Russian Federation and the Chief Court Bailiff of Russia. Thank you, Mr. Chairman. I have to be brief, but on the other hand, I should not reiterate what has been already said by other presenters. So I shall divert from my prepared speech, and I would rather comment upon some pending issues, and I would rather follow up upon some statements and some information offered by my colleagues, including my colleague from France. We really have a lot of issues in common. And my service does its work under the auspices of the International Service, International Association of Court Bailiffs. Next week we shall attend and take part in the International Congress of Bailiff Services in Madrid. That's where we are going to discuss harmonization of our professional efforts in different countries. We shall also discuss the model enforcement code, which may be a common ground instrumental for resolving a lot of pending issues. Now let me talk a bit about what's happening in the Russian Federation. I believe that we have all the three forms of
recognition and enforcement of court decisions. Yes, and one, it can be enforcement under the politeness, reciprocal politeness principle, without any treaty or without even as executor. And of course it is understandable when we deal with enforcement of court decisions where there are family matters, where the object of some court litigation. For example, in Finland, when a decision on paying the alimony is taken, they have a certain normative act, and decisions of our courts can be enforced there in Finland. And without such treaties and agreements, we can refer to our experience with Belarus. So we have a good history of enforcement of various economic activity decisions, and recently, just 2 weeks ago, we discussed this matter of alimony payments with our Belarusian colleagues, and we were discussing our future cooperation in this area. And the third is recognition by our courts of decisions of some international courts. Every year we get about 3,500 decisions taken in other jurisdictions. First, I would like to outline problems we face. First of all, it is an enforcement of decisions without an executor, and we're discussing this with our Belarusian colleagues. We realized that this is due not only with the recognition of this decision, but also within the enforcement and execution practice, there are certain differences in legislation of the involved countries. And here we need to speak not about discrepancies of some principal nature. For example, Russian and Belarusian legislation is quite similar. Now, the greatest problems are due to technical norms. As for alimonies, for example, we expect there will be serious problems related to calculation of the size of these payments and when these orders should be submitted and when they become effective. And through analysis of these technical issues, we have identified potential problems we might face in the future. We have established a working group, and we hope that this working group will develop recommendations for a better synchronization and harmonization of our regulations. I also would like to touch upon enforcement procedures. When we speak about efficient execution of cross-border decisions and awards, we need to speak not only of accepting these decisions on the territory of different countries, but we also need to discuss cross-border cooperation and assisting each other. For example, if we have to implement, if we have to enforce certain decisions here in Russia, I see that our French colleague is nodding, so he knows what I'm speaking about, and especially if it concerns countries on different continents or Russia and European countries. Yes, this is an acute problem. Even in the European Union, there are problems in this area. And here we need to provide some cooperation and assistance for these enforcement procedures because we see that we develop humanitarian and economic relations, and this means that assets of people, of those, for example, who have to pay in line with the court decision, but these assets are dispersed all over Europe, maybe, and we would like to get information about these assets, and I believe this is the very first step of our cooperation. And we communicated with our German colleagues recently, and they were speaking about this common registry in Europe. It is registry with beneficiary owners, with information on beneficiary owners of various companies. This is one thing, but then there is a question of how court orders should be enforced. For example, if court bailiffs in one country are trying to ensure this enforcement, there should be some ways of cooperating with court bailiffs in other countries as well. And this topic is really serious and relevant. But for us, it is important to establish some initial links and obtain this information, because in order to ensure efficient implementation of all these procedures, we need to know that this person or this company has certain assets, and the availability of this information may lead to efficient enforcement. Right now, we see effective results when we transfer these procedures into the criminal level, when we manage to qualify that this person evades from implementing a court decision, and this is treated as a criminal offense. When, for example, a person doesn't want to pay back a loan or alimonies for a long time, then through a decision of a criminal court, we might ensure this enforcement. And I believe this is also a serious problem, and I believe it is important for us to work on it in any country, and especially so when we speak about cooperation not only within Russia, but it is important for the Eurasian Union and with our nearby countries like Finland, for example. And I believe it has great significance, and we need to resolve them very soon. I'm aware that they are very complex, and even within the European Union, it is not so straightforward. Not so long time ago, we were preparing an agreement within the European Union, and Eurasian, not European, but Eurasian Union. We were developing the agreement together with the Ministry of Justice, and we expected that we would get authorities that enable us to have direct contacts with enforcement structures of those countries, and it didn't happen, and now we are initiating it again because we're absolutely sure that efficient cross-border enforcement is possible only through exchange of information and sharing best practices and procedures. Thank you. Thank you very much, dear colleagues. Are there any questions or comments before we have lunch break? Good afternoon. My name is Victor Dumler. I'm from Dumler and Partners Legal Practice. My question is about an important problem. This is recognition of court decisions. This is about a security provision by international parties. So my question is about these measures, because of course this is of really important nature. So securing measures. So I'm only asking about this. You probably know that the plenum of the Supreme Court in 2004 took a decision on securing measures, and it is stated there that securing measures of international courts are not recognized, are not enforced here in Russia. But if an international applicant may apply may apply to a Russian court. I don't think there will be any difficulties with that. I wouldn't change anything in this practice, because when there is a final decision taken, okay, and that's okay, but as for securing measures, our courts may adopt that as well. I believe that this position has a right for existence. I can only add that for court bailiffs service, this the whole situation is quite problematic because there's very low efficiency of securing measures in enforcing of international court decisions and even local court decisions. So we believe that there's a low activity in this respect, and this reduces efficiency of future enforcement processes. So I agree with Valery Abramovich that currently such measures, this is a painful procedure, especially a delayed procedure, and it should be in line with the Russian court decisions. Thank you very much. Dear colleagues, I believe we have had a very interesting professional discussion. I would like to thank all the speakers for this. And I would like to say that we have had a very positive discussion, and I expected something slightly different because I thought that we all would be speaking about all these serious problems. But now I see I'm quite optimistic about it, and I see that there will be serious legal changes, and there will be expanded conditions for enforcement of international court decisions, and there will be new treaties and bilateral agreements. So I believe this is really great, and I would like to wish you bon appetit and see you later. I'd like to thank you for joining us for this discussion. Thank you.